The next freedom that falls under Article 19, Clause 1, Subclause D is the freedom of movement. And in relation to freedom of movement, we would like to discuss two most important leading cases. One is Maneka Gandhi versus Union of India in 1978, and the second one, State of Himachal Pradesh versus Umed Ram Sharma in 1986. The very decision of the Supreme Court is relevant in the context of this freedom of movement as it is available under Article 19, Clause 1, Subclause D. So, in that connection, we would like to discuss the freedom of movement guaranteed by Clause D of Article 19 of Clause 1 is in addition to the right to personal liberty guaranteed under Article 21. Others of externment or internment violate this right unless they fall within the permissible restrictions. While judicial decisions confine this article to physical movement, the intangible aspect of freedom may receive protection under Article 21. For example, domiciliary visits by the police at night disturbing a person's sleep infringe personal liberty under Article 21 and may not be constitutionally valid except in cases of surveillance needed for the legitimate purpose of prevention of crime. In particular, entries in the bad character register at a police station, if malafide or subject to judicial scrutiny. A combined reading of Article 19, Clause 1, Subclause D, and Article 21 has led to the proposition that residents of hilly areas have a right to be provided access to the roads, which access is necessary for the proper exercise of the right of life. Generally, a person proposed to be extreme must be given a hearing. A permanent restriction on the freedom of movement is prima facie suspect. So, this very important decision tendered by our Supreme Court in the leading case, State of Himachal Pradesh versus Umed Ram Sharma in 1986, and the leading case relating to Maneka Gandhi versus Union of India in 1978, which would like to discuss when we will discuss Article 21. It is relating to right to travel and the issues relating to issuance of passport. And now we'll go to the second, the next important freedom, that is freedom of residence as it is available under Article 19, Clause 1, Subclause E, and in that connection we will discuss one important leading case, State of Madhya Pradesh versus Thakur Bharat Singh in 1967. The Supreme Court expressed that freedom to reside and settle in any part of India guaranteed by subclause E of Article 19, Clause 1 is subject to reasonable restriction in the interest of the general public or for the protection of the interest of scheduled tribes in general. Substantive as well as procedural reasonableness would be required to be followed. This freedom is said to be intended to remove internal barriers in India or between any of its parts, but is limited to citizens. Moreover, even citizens can be subjected to reasonable restrictions such as passport regulations. Besides this, certain areas may be banned for certain kinds of persons, such as prostitutes. So, these propositions of the Supreme Court, as was expressed in the leading case, State of Madhya Pradesh versus Thakur Bharat Singh in 1967, are relevant in connection to reasonable restriction, and those reasonable restrictions must also follow substantial as well as procedural reasonableness, and it is required by the state to follow both substantive as well as procedural reasonableness in those laws framed by the state in the very interest of general public or for the protection of the interest of any scheduled tribes or those ethnic tribes, those who are inhabitants in certain areas. So, freedom of residence as provided under subclause E of clause 1 of Article 19, as we have discussed, shall have to follow substantive as well as procedural reasonableness, as this very freedom of residence or the very freedom to reside and settle in any part of India, and it must not be affect the very general public or the interest of any scheduled tribe in any areas or any ethnic tribal community living in any specified tribal areas. So, such reasonable restrictions could be imposed by state, but such reasonable restrictions must have to follow both substantive and as well as procedural reasonableness. And in our next upcoming video, we will discuss the last freedom that is provided under Article 19, Clause 1 and Subclause G, and that is freedom of profession. And as regarding clause, subclause A of clause 1 of Article 19, which was dealing regarding the freedom to acquire, hold, and disposition of property as a fundamental right, it was removed and deleted under the 44th Constitutional Amendment Act in 1978. So, no more it was a fundamental right. Only it was removed and deleted. So now we found only 6 fundamental freedoms under Article 19, Clause 1, and among those fundamental freedoms, the last one, that is subclause G, falls under Clause 1, Article 19, that is freedom of profession, which we would like to discuss in our upcoming video.